Hi, I'm Clifford Bates, and welcome once again to reading Carl Schmitt's Dictatorship. Today, we're finishing the second part of Chapter 2, which again dealt with, the practice of royal commissioners until 18th century. 18th century. The 18th century was 1700s, right? The early 1700s is the beginning of the 18th century, until the 18th century Royal Commission. And this is the Excursus on Wallenstein, the second part of it, which focused on Wallenstein's and his things. And today we're going to be dealing with the second generalship. The first it dealt with Wallenstein kind of in general and the evolution of Wallenstein as the military leader of the emperor during the 30-Year War, and then the example of his general secondship is now going to be focus of the rest of this, the conclusion of part B of chapter 2. So let's continue. So, as Wallenstein's second generalship as supreme commander, that of December 1631 to February 1634, we do not have any authentic documents concerning the agreement between him and the emperor. So there's not much paperwork. There's not much was written down in that sense, right? The phrases normally used to describe Wallenstein's function are that he was given a commissarial in absolutis formula, unconditional commission, and the summa belli, the main issue of the war. The main issue of the war. So he was given the commission of this in absolutisma formula, the unconditional commission, and the summa bella. The transmission of command was made public on 15 December 1631 through an imperial edict. The official title of Wallenstein's office was the same as his appointment in 1628. That is the colonel. Is that weird title? As he says that, General August Field Captain. General Field Captain. Colonel General Field Captain. Right. 74. The line here is quoting the sources of it. He goes, the expression in absolute form proves very little by itself. At the time, it was used for any position that was free from any inherent dependency. So that was his idea. The phrase summa bella does not necessarily mean supreme imperium, because the summitatus, supreme height, was also used in combination with other words than imperium. So therefore, summitatus was not only used with imperium, it was used with other words. So therefore, for example, the princely councillors held by the summum officium, but they neither had imperium nor factilis discerni, the capacity to decide. Right? Again, and he now gives the sources for this in that sense, with this position. Exaggerated speculation on the actual content of his authorities is widespread. The oldest published document in a book from 1632 contained the pretentious declaration outlining the specific conditions which Wallenstein was accepted his second generalship. This document is not authentic, but it is a suitable basis for the examinations of Wallenstein's legal status. Its wording, according to the copy in the State Library of Munich, is as follows. This summary of the condition on the basis of which Duke Ferdinand has accepted once more from his Royal Imperial Majesty the command agreed upon by His Majesty's secret and royal consulars of war, in particular to the Dukes of Komaru and Egerberg, etc., to appoint him solus missus in sole commander. So, yes, most solely, one alone is what him most solely, and the same capacity, and in the same capacity as his last appointment. And this is the conditions: one, the Duke of Ferdinand should be and remain not only his royal, his Roman royal majesty, but also that of the House of Austria and the crown lands of Spain. So The Duke of Ferdinand should not be remain not only his royal majesty, but also his crown lands of Austria and of the crown lands of Spain. Two, that he should have command unconditionally, absolutis forma. Three, that his majesty, Duke Ferdinand III, is not personally present in the Armada and does not exercise command. And when the kingdom of Bohemia is reoccupied and reconquered, His Royal Highness should reside in Prague, and Don Balthasar should stay with 12,000 men in the kingdom of Salgovini until a general peace treaty is reached. Four, the emperor should guarantee Freiland a crown land in Austria as his ordinary compensation. So Freiland should be. He receives from the conquered land the highest kinds of royal rights in the Reich as an extraordinary compensation. 6. He is granted full rights of confiscation in the Reich, so that neither the imperial officers nor the royal court of Sprague should have any jurisdiction over it. 7. That Friedlander has full power in confiscations as well as in granting pardons, and whatever free conduct granted by the imperial court, it is not valid without confirmation of Friedland, even if it concerns only body and livelihood, not property. The concrete pardon stays with Friedland because the emperor might be too generous and pardon every single member of the court, and therefore the power of the the powers of the nobility officer and the army to contend this would be diminished. 8. In case peace treaties are likely to be negotiated in the Reich because of Friedland's private interest, the Duchy of Mecklenburg is also included. He should be compensated for 9. She should be compensated for all the cost of continuing the war. And 10. All imperial crown lands should be open to him and his army for a refuge. Addendum 1. The provision not only regulates the content of military command, as Richter assumes without question, it rather refers to whoever is the opposite party in the contracts. There is no mention of the fact that Wallenstein is commanding the League or the Spanish army. In fact, these troops were under their own command, which the Spaniards Castellanda and Fiera had received from the commission and authority of Ferdinand II, despite the fact that they were supposed to remain on good terms with the Wallensteins as well as within the army of the League. Right? This is note 76. In that sense, this is right. Ranke's History of Wallenstein. On 18 January 32, through a military order from Wallenstein, Aldring received the command of imperial officers and soldier stations Reich, but he had still should show respect to Earl Tilly, to confer with him on all issues concerning the German Reich and its loyal members, and to follow his instructions. Also negotiations with the General Commission of Bavaria. And above all, Wallenstein's letter to Aldring of 18 February 1632 showed in that as well, right? In it, Tilly is requested to administer justice by applying the martial law when the offenders would not submit to Aldrin's command. Wallenstein himself distinguishes between the ordinances issued by the Pappenheim Elector of Bavaria and his own decrees of request. He also mentions that he has compared himself with the Prince Elector. According to Richter, the respect for Wallenstein displayed around the issue of Spanish troops passing through was not only a respect for his actual power and cannot be ascribed to the regulations of any contract of employment in that sense, right? So again, this is again adding what the Spanish army is, right? 2, addendum 2. The phrase absoluta forma, which was popular in the 17th century, did not necessarily mean more than that Wallenstein was independent of the war councils of the court. In 1619, although Maximum Bavaria had demanded from the emperor plentium absolutus et liberum decorum, full, unconditional, and free command, in the execution against Bohemia. In any case, this only concerned military leadership and the administration army. Duxa externas and bella externa. In other words, leads the army and a war administration, right? Administration of the war. Yeah. And did not guarantee any authority or superiority of the state. So, in other words, he was only given commands of the leading the army and execution of war authority, war command, war administration, war administrating the war, not over a political, a political command in that sense. During the ensuing war, it was never mentioned that this emperor had ceased to be supreme commander. He even infers by means of interpositions. Again, 77, no, 79. On December 9th, 1633, the Privy Consul Earl Trautemendorf conveys to Wallenstein a final and altogether measured imperial decision to confront the Duke of Weimar immediately. The phrase definite will and order was already used in the instruction of August 1633 to Schlick. These three kinds and stages distinguished by Ritter in the development of imperial orders until 1633 do not relate to legal developments. Wallenstein's complaining in Pilsen about the emperor's order to besiege Riedenburg did not happen as if a right to neglect such orders had existed. In defense of Shigrov, states that the emperor, in other words, states the defense of Schafgoth states that the emperor had given Wallenstein such enormous powers, but it did not report the event in Pilsen any different. For example, the direct order from the emperor to his commanders, Gallus, Honus, and the others. See Richner's presented with this page. So therefore, he even infers by into positions into Wallenstein's affair, although the circumstances under which he made such intrusions were as of little constitutional significance as for the instance of his reluctance, noted by the Prince Elector Maximilian towards Tilly, where military operations were concerned. The emperor appointed the generals, even if Wallenstein proposed qualified subjects. The chief, the Augusts, were appointed by Wallenstein himself, by virtue of the generalship mandated to him. Again, point 5 of the letter of the prince to Poland, dated from 18 June 1632, is that issue. The colonel was in charge of the composition of the military command, right? So even throughout Wallenstein's second generalship, the cognitions of legal issues was for the cavalry in the hands of the field marshal, and over the infantry in the hands of the senior officer of each regiment. The general commanding officer handled all judiciary matters, and the field marshal or the senior officer summoned the court and issued the verdict. Essentially, in all of these respects, Wallenstein appointment did not differ from that of 1628, and the title reinforced that. Point 3. The close reading of the document does not demonstrate the widespread view adopted by Pufendorf that the emperor was probably not present in the army. Only King Ferdinand III of Hungary and the emperor's son is mentioned. 79. It is from this is evident that the text quoted above is more accurate than the edition of 1633 European theaters, of which only JKM is mentioned. The Hamburg edition explicitly refers to the Hungarian King Ferdinand III. Again, this is Schmitt as the a very meticulous historian in that sense. In that sense. In 1619, Maximilian of Bavaria II had forbidden that either the emperor or any other person from his court should obstruct the unconditioned and unimpeded command of the military operation. See above page 55, the thing we talked about earlier. And regarding add point 4 and 5, These stipulations concerning the agreement upon Wallenstein's personal compensation and reward and the guarantee thereof. Leopold von Ranke uses the monopoly on salt and mining as examples of the highest royal rights in the Reich by referring back to an Italian text, one of the una delle maggiori regale, one of the major royal prerogatives. See Wolfgang Mangel's Cromwell, right? On the right to be Prince Elector. Morris Ritter, on the other hand, finds here another illustration of the complete uselessness of this text, because in his view, the only possible interpretation of this formula is us or regale supremus ira supernus sic imperius, as us, as just. Or ego supremus as superior supreme right of the king, right? As this formula of us, or supreme right of the king, as a right of the king, or the supreme right of the king. That is, as a reference to the useful rights on tolls and contributions to war, was something of a monstrosity. In other words, referring to the useful rights of these things was something of monstrosity. They really negotiated whether Wallenstein was given the honor of being a prince elector on the basis of the report sent by envoys in 1632. In the jargon of constitutional law at the time, the honor of being a prince elector could be referred to as a supreme prerogative. So therefore, that wasn't. In other words, they debated the question: was he given the status of a prince elector? Because being a prince elector was referred to supreme prerogative. The distinction between high and low prerogatives is confusing, even in Michael and in in an otherwise clear legal situation. But there is no highest prerogative within a system of high or low prerogatives. And it was easy for Ritter to win the argument against Michael on these grounds. At stake here, in reality, is the dignitas regalis, the royal dignity in feudal law. So therefore, the stake here is the question of royal dignity, right? Whether they can't mean, in other words, it's going to be high and low prerogatives. There cannot be a highest prerogative in that sense, right? It's feudal law in that situation. The royal dignity in feudal law. For it to exist, there is a guaranteed hierarchy and order, and consequently also a supreme prerogative, right? Because of the order, there must be a prerogative in that sense. In those fiefdoms that count as the king's the feudal regalia, the king's lands, right, the royal fee or the royal and can only be granted by the emperor, the following hierarchy can be found, right? Regnum electoris dictus comitus baronatus baronus, right? So therefore, this is the thing: king, electorate, dukedom, count, and barony, right? Comitus baron. So therefore, in other words, in the fiefdoms of this Rajya, there's only this hierarchy: the king, elector, the elector, then the duke. Yeah, duke, the count, and the baron. Right. Feuda regala was fiefdom, and were accorded the dignitas regalis, the royal dignity, through the emperor's edict. Although the highest royal dignity, right? Again, this is the dictus was the king. So therefore, these were all given this, but they were given proportional in that sense, right? That the highest was the regnum, next highest was that, then the duke, then the count, then the baron, right? But that does not concern us here, because only the highest regal in the Reich is mentioned. So the phrase makes perfect sense in that sense. In that sense, the idea that this supremest right, the highest one, is of these royal dignities, the supreme one, Only the king is that's the supreme one. As therefore that does it makes perfect sense in the title of that phrase, right? Moreover, because the reward, the compensation, was for extraordinary things, right? Unlike the ordinary compensation is not unlike the ordinary compensation is not a sum of money. It is rather a dignity, a dignitas, which is something different from a compensation for the costs and expenses that occurred, as it is also clearly distinguished from the agreement with Maximilian Bavarius 19. The phrase clearly corresponds to the correct terminology of constitutional law at the time, so much so that it could be proof that this could be proof of the usefulness of that book in that sense. Because so it said, for the concept of dignitas reglas, see Damocus Ancurais, the discourse. Sorry, the academic discourse on public law in 1621. Um, Concerning the royal dignity and fees attached to the royal dignity, and Discourses 15, Die Regibus, on the king, on the on royalty, on the king. What is it? On Regibus. I think that is on the royal day, right? Of that. See chapter 2 on the emperor's right to grant electoral dignity. Theodor von Rheinkink, the of secular and ecclesiastical government, 1659. A reference to that, right? It's, 1969, book one, chapter, no, volume one, book uh, uh, 4, chapter 16, notes, or, section or whatever, number 5 and 8. One can also find their reference to the literature of 17th century. Our Arnesius, the Republica 2, mentions the distinction between the feudal regalia, the feudal dignity, and the feudatory subjecta. Okay, what is this? Subject to another fee, and the feudal regalia. The royal fee, the riga, the royal obligation, and the feudal obligation, the fee or the not thing, the fief in that sense, the feuda of another third party, right? With the context of the question of divisibility, the feuda regata, the feuda regata like this, the royal fief is indivisible, but third party fiefs were divisible in that sense, right? During the 18th century, the idea of modern understanding of territorial sovereignty disappeared. So all of a sudden, in other words, it's in the 18th century that the idea of territorial sovereignty, sovereignty of a piece of a land in that sense, a specific fief and title, the sovereignty of authority, this has appeared. The electoral dignity remained, however, as a recognized fiefdom. In Ritter, I think the fall of Wallenstein, states that Wallenstein is reported to have received the highest kind of royal rights of the Vanden, i.e., of all the occupied lands. This is not a compelling interpretation if you paid heed to the text. From the from the occupied countries mean from out of and occupied territories. So those from or out of occupied countries, with reference to the counties that had been conquered during the war. Okay. So now point 6, regarding point 6, right? This point concerns the securing of the army supply. In Merriam's theater, the European theater, the phrase in absolute form is used again instead of the word of bad. And the text continues in such a way that neither the imperial Hofsaraf, Hofsaraf, or nor the imperial treasury, this is the body of that, nor the imperial court and spire can claim any interests or has any power to make any decision, general or particular, or can interfere in any other way. Right? This is on these points. Compare the Hamburg edition. Right. On 15 April 1632, an authorization from the emperor accorded Wallenstein the right to pass judgments in criminal acts, in cases of criminal acts, and to order confiscations not in the right but also in the crown lands. Right. Subdelegation 24 November 1633. Wallenstein declares that since the emperor has given him by way of cover for the needs of warfare all the goods taken as penalty, he does have the power to accept such goods from the Kedres registry in Bohemia or elsewhere, or to send authorized persons to do so. The commissar should take on our name any actions that business demands, without distinction about judging it and dealing with it as if it were to do it ourselves, in that sense. The king, emperor himself, right? Section point 7, the stipulation is again about securing supplies for the army. Granting free conduct is seen as purely a financial matter, as the writ of protection for individuals and countries. Point 8, the point deals with the agreement in favor of Wallenstein in securing army supplies. Point 9, Ritter and Gustav Adolphus plan, the plan of Gustav, points out that the emperor provided only some financial support. He did not pay for all the expenses. The theater, European theater, calls them spam or expenses, right? But the agreement also states that Wallenstein will be reimbursed for all his expenses after the peace agreement. Here too, we can detect an analogy between the agreement of 1619 between him and Maxima in Bavaria. In point 10, as Ritter explains, the fact that the army was permitted to retreat to the lands of the imperial crown is, to be sure, self-evident in emergency. Hence, it goes without saying, of course. But here, we are not dealing with a matter of emergency. Moreover, the sentence is about the right to recover by using the resources of crown lands, even if no case of emergency has occurred. The absence of any meaning of emergency is the most important part of that sentence. So the absence of any meaning of emergency is the most important part of that sentence. These 10 points do not prove anything about dictatorship. Their essential interest lies in the area of proprietary law. The appointment was not a problem at all in terms of constitutional law. So the issue was a proprietary property law problem, not a constitutional law problem. One could rather say that it was the appointment of mercenary soldiers. In other words, that it was. One could rather say it was the appointment of mercenary soldiers, right? As far as constitutional relationship between Wallenstein and Emperor goes, the latter was still the supreme commander. He had only commissioned Wallenstein to lead the military operation and the administration of the army, although in reality he had given him greater freedoms to act. At point 4, 5, 8, and 9, we find agreements concerning Wallenstein's payment and reimbursements of his expenditure. Political functions are not mentioned in this document at all. On the contrary, point 8 proves that negotiations for peace was not dependent on Wallenstein, so Wallenstein couldn't control it. Even supposing that Wallenstein was sometimes giving omnipotent power. Um, Plenty. Okay. absolute power, in other words, complete power planning, or arbitrum of war and peace, the ability to arbitrate war and peace, right? To make decisions regarding war and peace. Look at note. Okay, this is me that. This would have conflicted with the fact that all of Wallenstein's negotiations were undertaken either with a particular authorization or with the imperial reservation that the emperor had to ratify them. So again, 83, this is clearly the case with the evidence. In other words, it wasn't his authority alone. He had it, but he had to do it with either what he did in negotiations. If he, if he Wallenstein negotiations were undertaken, they were done under with particular revelations or with imperial reservation that the emperor had to approve it. In a resolution dating from 3 February 1634, the Prince Elector of Saxony gave the following answer to the question raised by Arnim, of whom one would have to negotiate with. With the Duke of Friedland as the imperial and highly esteemed plenipotentiary, the one of full power, and fully authorized person, since this person is not waging war in his own name, but in the name of and in obedience to the order of his imperial majesty, and the army still belong to his imperial majesty, and as the Duke of and officers and the troops have made familiar, his imperial majesty has not completely given away the decision of making war and peace. Rather, it has reserved it as the supreme us magisterium for himself, the right of majesty himself, supreme right of majesty for himself in that sense. And this is the German text. This is the translators left the German text. So therefore, in other words, it even though that he had so much authority, the text says that no, but the emperor does. Even though negotiation has given power to these things, it is that. It also emphasized that all the military powers are insufficient to form the basis of negotiations towards a peace treaty. Again, from the same resolution, which is number 5 in von Recke's Anaculum, it is evident that all Wallenstein's negotiations depend on imperial ratification, and thus the illi grera circa bella administratio was not fundamental for peace treaties in the sense. The extraordinary status that was given to Wallenstein during his second appointment consisted in an extraordinary autonomy for a military commander and an extraordinary reward. So he was given extraordinary autonomy and extraordinary rewards. This appointment would have been a dictatorship only if its consequences would have impacted upon the objective legal situation following a legal situation, therefore constituting a state of emergency. In other words, this appointment would have been a dictatorship only if its consequence would have impacted on the objective legal status constituting the state of emergency. Such an impact did occur through the practice of collecting contributions and imposing confiscations that, in the interest of warfare, had been hugely expanded over the agreed limits. But it is true that in a critical situations, even military actions had to demonstrate a boundless, every military action had to demonstrate a boundless capacity to stretch towards the desired end. In other words, you had a desired end was peace, status, this goal of establishing peace or establishing order. But the military ends had to go to that. You could do that, guaranteeing the supply that was directly related to the strategic and tactical conduct of the operation was needed not only in the interest of warfare, but also for the army's equipment and maintenance, for logistics, for gathering of intelligence, for discipline and morale, and not only in one's own army, but also that of the enemy, so that with the expansion of the perimeter of operations and changing in technology, the whole state ended up being subject to military ends. In other words, the thing about this is that the nature of the war itself, relating to the war, and the size of the war, and the way the war spread. This, therefore, the whole, as he said, the perimeter, in like that sense, right? And because of the change of technology, the whole state ended up being subject to military ends. In other words, the state became a technical instrument of achieving a certain goal. So therefore, the whole state became a technical instrument for the army in that sense. In order to secure the army in waging its war and doing its things, in order to ensure that they were able to do it and things like this, that therefore the whole state became connected to a technical means for the army to do its job. And therefore, this is what he means by that, in that sense. The state became a technical instrument in achieving a certain goal. The development of the Prussian commissariat of the army, what has already been described in the historic example of the potential of stretching the limits in order to achieve a certain goal. So therefore, this is the example of the Prussian commissariat army, which was discussed earlier. This moved a certain goal to achieve a certain goal, right? Such a purely instrumental understanding would, of course, have perfectly suited Wallenstein's thinking. He was an extraordinary organizer. He did not just raise a huge army in the most difficult circumstances. He also administered his own land at the same time, and in such a way that he subsequently, in such a way that subsequently they became an example of a great mercantile state, solely governed through instrumental reason. So therefore, that's an even more interesting point. In other words, not only did he organize this for the army, but rather he organized it his own lands and that stuff, and that became in such a fashion that it became a great mercantile state, solely governed through instrumental reason. For such a person, respect for the constitution of the Holy Roman Empire and for traditional privileges was always unconceivable. In other words, this person with this great power. In other words, in this person, he was an organizer, extraordinary organizer, and not just regarding the huge army, but his own administration. He was also a great mercantilist that solely governed. And therefore, in other words, for such this kind of person, respect for the constitution of the Holy Roman Empire and its traditional privileges was always, in a personal postscript to a letter to Trautmandorf, Wallenstein remarks, "Those who are coming to me from the Reich tell me a lot about the Reich's policy." In other words, those who are coming to me from the Reich tells me a lot about the Reich policies, the Golden Bull, and so on. I don't know how I can get my head around these things when they present them to me. In other words, he doesn't know how to get these things. He doesn't understand them. It doesn't make sense. Don't make any sense to him. He's kind of saying, right? Those who come to me from the Reich tell a lot about the Reich policies, the Golden Bull, and so on. I don't know how I can get my head around these things when they present these things to me, right? This is like, let's do this 85. Again, this is from that. Okay. So he says a collection of contributions based solely on military considerations, and even more, a more ruthless practice of confiscation could now have provided the means to abolish the legal hindrances in that sense. In other words, a more ruthless. In other words, military considerations and even more ruthless practice of confiscation. The authority to impose confiscations, however, was only directed towards enemies and rebels on the one hand. It had been the practices of all revolutions that stigmatized the political opponent as the enemy of the fatherland, and therefore rob him more or less completely of legal protections for his persons and his property. Nevertheless, it was far from the emperor's intention to use such methods in the name of revolution. So the emperor didn't. In other words, you could have used the revolution, that you could have done this and that, done this to change the thing, but the emperor didn't want to change the thing in that sense. He's saying. Not even the imperial commissar saw himself as entitled to apply a treatment exclusively dictated by the instrumental considerations. So not even the, in other words, that nevertheless, it was far from the emperor's intention to use this method in the name of changing the thing. Therefore, not even the emperor's commissioner saw itself entitled to apply a treatment excessively dictated by instrumental considerations. He did not dare to take advantage of the situation of war to extend his political authority by trying to impose a extraordinary rights, juris extraordinary, an extraordinary rights of his plentorial power, possibly because he feared Wallenstein's huge and overwhelming impact. In other words, the emperor didn't do it, but maybe he didn't because he feared. In other words, the argument that Schmitt is saying that he did not dare take advantage of this. Because why? Because he feared Wallenstein's huge and overwhelming impact. It was intrinsic to the principle of the monastic arcanaea, the secrets of the monarchy, not to allow an official or a general to become too powerful. So therefore, this is the principle here, that it was an intrinsic to the principles of the monarchic sciences or the monarchic wisdom, archaea, the knowledge, the monarchy, not to allow an official or general to become too powerful, right? Um, and that this was, by doing this, made him too powerful in that sense. The principles of monarchical government can be found in the forms of extortion to the prince and princeps in compatio. Prince and Savings, a book from 1632 that is attributed to Ferdinand II, and was certainly written by someone in his circle. It is alleged. It is allegedly a kind of last will and testament of Ferdinand III to Ferdinand III. There it is stated, no doubt, in allusion to Wallenstein, that the prince should not give any. Uh, okay, we're going to read this in Latin complete. Free and absolute power, so that he may act without his knowledge and all other things which are supreme and absolute authority, but the prince himself remains the general. In other words, this is, in other words, that, oh my God, this is like this Ferdinand II's Principes and Compendio. That, okay, what is he saying here? This is actually pretty good. They say, in allusion to Wallenstein, that a prince should not give what a free and absolute power, so that he may act without his knowledge and all other things which are supreme and absolute authority, but only the prince should remain general. So don't make another Wallenstein. The text of the 1668 edition is reproduced in Aulich's essay, special edition, published in the fifth issue of the Viennese Montblatt. Okay. Monthly newspaper for the Association of Regional Studies of Lower Austria in 1906. And again, this is the Schmitt as a scholar is boundless in a sense, right? And let me just even say the quote here, because that again, the different translation here. It is stated that Wallenstein, that Prince should not what boundless unconditional power, so that he may act without the prince's knowledge, and especially in matters containing unconditional to the highest powers, but the prince himself should remain the general in charge of this. On the other hand, in 1630, in order to dismiss a proposal of submitting the army to the supreme command of the Maximilian of Bavaria, the imperial consuls turned against the prince elector himself in the political axiom that nobody should be made so powerful that one would have to depend upon his discretion, right? So therefore, this is again he turned against. On the other hand, in 1630, in order to dismiss the proposal of submitting the army to this, that it was going to be dangerous because that would make him too powerful, right? Therefore, the emperor was in a precarious situation on both sides. Respect for the existing legal system had tipped the scales. In other words, yeah, he was threatened by Wallenstein or the elector, and therefore, oh, let's accept the. In other words, let's respect the law in that sense, right? The legal tip the scales. This is the real heart of the discussion about Wallenstein's dictatorship. In other words, it was the fear of the authority, right? In other words, the real heart of Wallenstein's dictatorship is about the question of, the existing legal that the emperor himself was in a precarious situation and was going to be threatened. That this situation was threatening the emperor in that sense and the emperor's power, and therefore this is what. Let's read the next line of this. In fact, it was all about whether the supreme imperial authority in Germany was the kind of institution that could abolish customary rights when they stood in the way of the state emergency. So the real question was, did the imperial authority in Germany have was the kind of institution that could abolish customary rights when it stood in the way of a state of emergency? The question of Wallenstein's status vis-a-vis the emperor became insignificant by comparison with that of Wallenstein's dictatorship, because the emperor had not decided to impose extraordinary rights for himself on the basis of his imperial plenitude of power. In other words, this is therefore, in other words, this idea that he didn't. This was, in other words, he didn't grant himself the right to do this. In other words, the emperor himself didn't grant this. He didn't make that claim. So therefore, the question of this, in other words, let's repeat this again, that the real heart of the matter about Wallenstein's dictatorship, right, is the fact that it's whether the supreme authority had this power, right, or not. The question of Wallenstein's status vis-a-vis the emperor, right, is insignificant in comparison with that of the Wallenstein dictatorship. Because why? Because the emperor had not decided to impose extraordinary rights for himself on the basis of his powers, right? Ferdinand III's capitulation of 24th December 1636 was the constitutional expression of the fact that the emperor had lost his last chance of establishing a strong central power by appeal to the state of emergency. So therefore, this act, 24th December 1634, was the constitutional expression of the fact that the emperor had lost his chance to establishing a centralized power by the state of emergency. In the extreme need, the emperor was no longer bound to consult the estates, although he was required to consult 6 princes electors in order to levy the most basic contributions. In other words, he could not levy provisional contributions himself simply by referring to the state of emergency. Not even in high-profile situations, a breach of peace, or a continuing rebellion, was he allowed to declare a ban without the agreement of the prince electors. Even in high-profile situations, a special legal process was compulsory in the emperor's prior position that the ban could be ipso facto, simply by simple fact implemented, was no longer possible. So therefore, the previous position of the emperor that because of the peace I can just implement this. No, he needed to do these things to pay for or to do levies. He needed to get the approval of the electors. Lemus and the constitutional Lemus, the constitutional legal theorist, remarked that the state of emergency was the favorite excuse, but the king was deprived of this. In other words, the state of emergency was often the excuse that allowed them to centralize power, to expand his power so that he could centralize. Right, this was the thing. But the problem with the emperor was that the Kaiser did not do this. Right, he. But the Kaiser, the king, was the Krone. I don't know. I think Kaiser here is going to be the word in German. The Kaiser was deprived of it, not really. And he was decided according to his will that even extreme necessity Even in the case of extreme necessity, extremo necessita causa, the case of extreme necessity, right? In the extreme case of necessity, he had to consult at least the prince electors, right? He still had to consult it, even in the extreme. In other words, that he did not decide according to his will. Even extreme this, he had to consult at least the prince electors. This must have made it impossible to transfer the mixed status. It was impossible. It made it impossible to transform the mixed status of the Roman Reich into a pure monarchy by the appeal of the state of emergency. So therefore, the feudal system, the feudal structure of the Reich, the Roman Reich, the Holy Roman Empire, it was impossible for them to do this. Therefore, this is a devastating critique of the feudal system in the sense that the feudal system and the feudal structure of this and the nature of the Roman Reich and its principle, the emperor really just could not do it. He just was not willing to do it. He was too terrified in that sense of doing it, or not. He's too he did not see him having the status of this. Linemus's constitutional theorist, 87. He says Johannes Linemus find a 5-volume work, The Public Law of the Germano-Germanic Empire, the Holy Roman Empire. Volume 5 had already polemicized against Rinkik. Again, this is 1640, and denied the emperor's plenitude of powers. He says the text also cited can be found in Limanes Capultus. Okay, is this? What's this? The capulations of the emperor and a king of the Roman Germanic, Germanic, and of the Roman the kings of the emperor and kings of. Nevertheless, Ferdinand II was portrayed as a tyrant by Hippolytus at Lappe, Philip von Klemps, and a case of legitimate resistance was raised against him on account of a violation of the Constitution. This is the rational stuff. This is the Klemptis book on the account of the state. The Rationale of the State, Part 1, Chapter 7. Against Ferdinand, the reference to the complaint was made by the Prince Elector. Okay, this is the reservation D 1631. Let's do this. On the Emperor's reserves, reservation of the Emperor. So that's it. If you have any comments or questions, please put them below. This ends Chapter 2 of Schmitt on the examination of this in the feudal system. We're going to turn next to Chapter 3, which looks at the 19th century, 18th century, the 18th century, which is the more modern. This I think it's going to be looking at the Hobbes-Locke, post-Lockean, Hobbes-Lockean world, as particularly done by Montesquieu and the Enlightenment, and then which is the absolute time of absolute, the beginning of early absolutism in this sense, and then we will have also and Rousseau too. That's the other one, Rousseau and the modern thinkers. So the 18th century will be the height of the next book, Chapter 3. If you have any comments or questions, please put it in below, and we'll get to it. If I see it, I will get to it, respond to it. Please have it there if you have any issues or concerns or any things you want to maybe get further knowledge about. Dictatorship is a great book in this in terms of what it does. It's his understanding of the legal structures of the Austrian-Hungarian, the Austrian-Roman Empire, the Holy Roman Empire, the German Germanic Empire, and this feudal structure and the feudal law. And this is, and how the example of Wallenstein here was really saying that it wasn't really a kind of a dictatorship or a centralized state. In the say, it was not. In other words, it wasn't the creation of it had elements of the commissarial dictator, but not completely it was always restrained by law in that sense. It didn't have an understanding of its absolute state in that sense, the modern state. It had too much using the Schmitt's own discussion. It was more kind of based on the form of the state, the medieval state of this was still a kind of a jurisdictional state where there was specific jurisdictional entities that had specific rights and authorities and limits to authority. It was not a centralized authority to do something, and that the emperor himself was not willing to centralize. Right, that's the whole lesson of this thing. So if you put your comments there and issues of that, please do so, and I will respond to them when I see them. If you like it, like the chapter, hit the like button, hit the share it with a friend, share it in social media, get it out there. Maybe some people will be interested. Hey, it's a dictatorship. Yeah, this is why Schmitt. Reading the Schmitt more carefully, you see the. I'm actually seeing, to be honest with you, seeing the problems of translation. I'm getting more and more to the point where I feel I need to get a new copy of the German, because I'm just saying, okay, no, that's the wrong. It's not the king; it's the Kaiser. It's because the king is a much limited construct. So I'm looking at the way the words he uses and how he uses them. Translator is, this is a good. I mean, I understand the virtue of it. Now I'm seeing the little teeny, slightly flaws that really would shape us in that sense. So again, like it. If you didn't like it, you can always hit no, don't like, but say why in the comments. What I do wrong, what did you disagree with. Second thing is that if you're not subscribed, subscribe, like the World Channel some. Another thing is that you want to follow me on social media, links are below. You want to follow me as an academic, and my academic social media links are below as well. My scholarship and things like that, the links below. If you want to help me to do what I do, to become a financially contribute in that sense, it would be good. Would it be nice, right? It would help life. Life is so expensive these days. You can do so through subscribe to our Patreon. Um, I don't think anyone's doing it. No, I'm not doing it. Not right now. Okay, I understand. Um, what else? That's it. Um, oh yeah, another way you can help me is buy one of the books. My books. You can help me doing this. Buy one of my books. Um, Listed below. The books are this, they're there. I list them there, so you can go to Amazon or whatever site you want to go to, or go to your local bookstore. Those are the way to help. Well, that's it. Again, the Schmitt section will continue. Schmitt, looking at next time at chapter 3, as we said. I'll divide it in two parts. Part 1 and part 2 to make it a little more doable. And then what we'll do is we will go on to on Monday, Tuesdays on Rousseau. By the time you see this, I think we'll be doing we'll be continuing Rousseau, but we'll be doing Rousseau's not Geneva, the political economy, the piece from the encyclopedia. Why am I doing that? Maybe I'll do. I'm thinking about doing Letter of John Boat, and maybe even. We'll do it Rousseau. Another Rousseau. Let's see what happens. Okay. Well, take care. That's it. And of course, Fridays are, either live stream or some live activities. Take care. Have a good day. Bye bye. So long. See you again.